The following is a CUNY TV special presentation.
I think the odds of getting a shield law passed, certainly by the Senate and then maybe by the House, are very large. It's very, very likely the Senate will pass a bill this year. Just about every Democrat is for the bill. That's from my own personal lobbying, as well as the newspaper publishers and all the other groups and journalism lobbying them. We have 5 Republicans on record being for it. 3 of them are our co-sponsors, Graham, Blunt, and Isaacson. And then in committee, pleasantly enough, Grassley and Hatch voted for it, and the fact that Grassley is the ranking member of the Judiciary Committee helps. So we'll get a few more Republicans, not many more, but we have the 60 votes, and additionally, we are now making an effort, Lamar Alexander and I are trying to do this, to put some bipartisan bills of significance on the floor that can actually pass. And so I've spoken to Harry Reid about getting floor time, which is very precious, and he seems very sympathetic. So I think we're going to get the bill on the floor of the Senate and pass it.
In reporting for a column on this subject last year, I was slightly surprised to discover that there are some very ardent conservatives who support this. I think somebody like Ted Poe, who may have agreed with you on one issue out of 10,000
Exactly.
in the course of your careers, is a House sponsor of a bill which actually at that point was more liberal than yours, or more favorable to the press than yours. So who's against it?
Oh, well, the whole, most Republicans are against it. They don't want any exception for national security. Present law, as you know, is if the government says it's national security, the journalist has to testify, period. No ands, ifs, or buts. And what people mistake is, there is no First Amendment right for gathering information. There's certainly a First Amendment right for putting forth information, but not in the way you gather it. And so there are a lot of people, particularly the national security side of the Republicans, who are against it. We had until we made the compromise that is somewhat controversial, having more limited protections in national security, the administration, the Obama administration, and Attorney General Holder were against it. Mm-hmm. It mainly comes from the national security side.
The Obama administration, just to be clear, is now in favor of your bill,
They are,
correct?
because there are limits in terms of national security. I was for basically a balancing test even for national security, leaving it to the judges that they could weigh the interests of national security versus the need for free press. Mm-hmm. But until we put limits on national security, there's still a lot better than present law, where they can come in and say, national security, testify, period. Mm-hmm. Ours, it has to go before an independent arbiter, a judge. You have to prove that it is national security, so you can't just make it up or say it or stretch it. And not just you have to prove it's national security, you have to prove that it will do future damage to the national security of the United States. And finally, it gives notice, so that the journalist, you're not going to have a Rosen or a Reason situation where there was no notice at all.
Mm-hmm. Okay. Well, one of the key issues in the drafting and debating of this piece of legislation is the question of what's journalism, who's entitled to be called a reporter in a time when anybody with an internet service provider can be a journalist.
Right.
So what's your definition?
Well, the bill is not the definition we started with, again, because my job is to get something passed and make the situation better, and it's been my credo my whole life: I don't let the perfect be the enemy of the good. The original bill I introduced said that as long as you had an intent to gather news, you were a journalist and protected. Mm-hmm. And 2 people on the Democratic side in the committee didn't like that, Senators Feinstein and Durbin, whose politics are much more similar to mine than the people who opposed it for national security. But they thought that, bloggers and people like that, they wanted just traditional journalists to be protected. And so we came up with a compromise. And the compromise basically says 3 things. If you're a traditional journalist, you are covered. And a traditional journalist doesn't just mean someone who writes for a newspaper. Our definition does not separate the medium by which you send out news. But it does say that you have had some relationship in terms of being a journalist, some commercial relationship at some point in time. If you have it now, you're being paid by somebody to do something, you're fine. If you had it once in the last 20 years, for a year or so, you've written 5 freelance articles, you're covered. The people who are not covered, I wish they were, but they're not, automatically are people who have written freelance articles and never gotten paid for them. And that they should be covered. So what we did is we put in a safety valve, that if you're in that situation, you're not automatically covered, but if the judge finds, and I wanted to get the words right here, that it is, quote, in the interest of justice and necessary to protect lawful and legitimate news-gathering activities, you are covered. Most judges have been quite liberal in this. Most state judges have been quite liberal in applying this law. And frankly, we did not get too much opposition from the blog or new media community when we put this in. They didn't like it, but they thought it was a pretty good compromise given the fact that we needed those. If we didn't have a unified Democratic front and Judiciary Committee, I wouldn't have been able to give you the answer about the bill passing.
Okay. The previous panelists included Glenn Greenwald, who lives in Brazil and who said during the discussion that he worries about what consequences might befall him if he returns to his native land, this one. Would anything in your bill set his mind at ease?
Well, yes. Bottom line, now this is clearly a national security case, but there'd be a judge who would have to rule that bringing Glenn Greenwald forward to reveal his sources would protect the future security of the United States. That's a lot better than the Justice Department saying you have to reveal your sources, no contest, no independent arbiter, et cetera. Now, clearly, if the judge thought that there was future damage, potential damage to the security of the United States, he would have to testify. There's a chance he wouldn't, and that would be up to the judge, and you'd have to look at the ramifications of the case. And he'd get notice so that he could prepare, as opposed to someone just swooping in on him and telling him you got to do it, or taking his records, or looking at who he called on his phone, on the phone, et cetera. So he'd have. It's probably not enough protections to satisfy him, that's for sure, but it's certainly better than present law.
His concern is not only that he might be compelled to testify, and in fact, they don't have Edward Snowden here to prosecute, so that there isn't a proceeding yet where he could be compelled to testify, I guess. But his concern is that, judging from the language that some of the national security officials of the administration have used, like co-conspirator and accomplice, that he might actually be charged himself under the Espionage Act.
I wouldn't know. I'd have to examine the law specifically and see whether he was in jeopardy or not. I couldn't give you an answer off the top of my head.
Okay. Can you talk a little bit about Julian Assange, another famous non-traditional media figure of recent years, who is currently encamped in an embassy in London because of his various legal complications. Would he be protected, first of all, under the Shield Law, and should he be protected more generally for being both the broker and publisher of the WikiLeaks?
Okay.
trove?
On the first case, if he had any kind of commercial relationship as a journalist, I don't know the details of how he operates, he would be protected. If he didn't have any commercial relationship, you'd go to this test of in the interest of justice and necessary to protect lawful and legitimate news gathering, and it would be an independent arbiter to decide. So depending on the details of how he operated, he would have protection. If there was a commercial relationship, which is there? I don't know. I don't know the details, how he makes money, how he, as my mother would say, how he earns a living.
Well, I think he raises money the same way NPR does. He asks his audience for it.
So I think that would probably be defined as a commercial relationship.
Okay, and I can't, because he's a former colleague and a friend, not ask about Jim Risen, the New York Times reporter, who is faced with the prospect of jail for refusing to identify his source in a story about U.S. intelligence activities in Iran.
Under our bill, Risen would have a day in court with an independent judge to determine whether he had to reveal his source.
Okay. And it would be a balancing test that the judge would
That is correct.
carry out.
If it's a national security, it's the test that I mentioned before.
Okay. We're going to let you go and bring the panel out, but before we do, I wanted to ask something that's sort of a context question that I've sensed is in the air a bit at this event today. The Obama administration has not been particularly regarded as a great friend of, certainly of leakers and by extension of the sort of reporters who make use of leaks.
Right.
In their litigation, they've argued that there is no inherent constitutional privilege protecting reporters. They have, as you know, indicted more leakers under the Espionage Act than all previous administrations put together.
Yep.
What's going on there? Is this just a case that when it comes to national security, Democrats have to be more Catholic than the Pope, or is there something else?
I'd put it a little more broadly than that. And I've heard this, you know, from various presidents, not just Obama, but Bush and Clinton as well. And that is when you become president and you see all of the national security dangers out there, it's a revelation that as a candidate, as a senator, as anybody else, you don't really have. And so you end up being pushed a little bit more to the middle. Whether that's right or wrong or not, I wouldn't comment. They did make an effort. As you know, I'm trying to figure out here, I'll get it for you. They put out some guidelines, which are not good enough, but an improvement over current law. Although the great weakness in their guidelines is not their fault. There's no independent judge. And still under the guidelines, if the Director of National Intelligence says national security, that's it. But there are some safeguards regarding notice in particular. Journalists really need notice in just about any situation so they can defend themselves, so they can prepare, and all of that. And they do put that in. So the guidelines in the administration's defense are some improvement. They're not as good as the bill, but the administration, after we made these compromises on national security, is now for the bill, so that's a good thing.
Okay. Senator, thank you for being with us today.
Thank you very much. Thanks. Good to see you.
Good to see you, Senator. Ken, welcome. Jonathan Landay is the Senior National Security and Intelligence Correspondent for the McClatchy Papers and has been awarded just about every honor that our business confers. He's perhaps most admired for his reporting on the cherry-picking of intelligence in the run-up to the war in Iraq. Quinn Norton is a writer who, as she puts it on her website, likes to hang out in the dead-end alleys and rough neighborhoods of the internet where bad things can happen to defenseless little packets. Her reporting on hackers and many other subjects has appeared in Wired, The Atlantic, The Guardian, and other not-so-rough neighborhoods. Scott Horton covers legal and national security affairs at Harper's Magazine, is also a lawyer and a lecturer at Columbia Law School. He's the author of a forthcoming book, The Lords of Secrecy, about the rising role of secrecy in national security. And Kurt Wimmer is a partner at Covington & Burling, general counsel to the Newspaper Association of America, and has long represented the coalition that supports federal shield law. I've got a lot of questions of my own, but I'm going to strongly encourage you to jump in and challenge one another as the opportunity arises. And Ken, I'm guessing you're outnumbered here. So the first pitch is to you. Okay. In a presentation at the Heritage Foundation in September on the future of anti-terror efforts, you said, quote, Congress should maintain its record of largely resisting legislation that unduly restricts the government's flexibility in the fight against international terrorism. Does the SHIELD law fall into the category of undue restrictions?
That's a good question. I hate it when you actually use my own words against me. But that, I think that was more talking about investigative tools and limiting of investigative tools, such as scaling back on national security letters, scaling back on electronic surveillance, that kind of thing. I put the Free Flow of Information Act in a different category. It doesn't limit unduly or not the government's effectiveness in terms of its ability to detect terrorist plots, and we'll talk about terrorism for now, terrorist plots and that kind of thing. But what it does is it undermines the ongoing effectiveness of government operations. And obviously, you know, look, as we've discussed here all day today, there's a balance to be struck between two very important principles: transparency, the need for transparency in a democratic society, but also the need for secrecy. And I assume we'll hear more about this from the other panelists, but over the last 12 or 13 years, there has been an enhanced, the zone of government operations that are very secret has increased because of the counterterrorism threat, because that by definition needs to be done in a covert manner. And the type of investigative activities that the government has undertaken to take on that threat have moved into new realms, which raise new concerns. Concerns about privacy, concerns about overreaching, concerns about whether the government is going too hard or not going hard enough against terrorists. All are matters of intense public interest. That has sharpened that tension between the need for transparency and public discussion about what the government does and the need for the government to maintain secrecy. So I would say that the shield law doesn't necessarily curtail a government's investigative, the reach of government investigative tools, but what it does do is it undermines the effectiveness of the government in a number of ways, and I'll talk about this later, but it undermines your ability to launch operations and do so without worrying they'll be compromised, to develop sources, and all you have to do is read the 9/11 Commission report to see that one of the main reasons why 9/11 happened was we didn't have human intelligence. We hadn't developed human sources. You can only develop human sources if those sources and potential sources have confidence that they won't be unmasked and then killed by our adversaries. Undermines the ability to use important methods such as Stuxnet and codes and that kind of thing. So at a range of areas, leaks undermine the government's effectiveness, and if you have a law which makes it difficult for the government to prevent those leaks, and one way of preventing them is finding the people who do it and punishing them in order to incapacitate them as leakers, but also deter other would-be leakers. If you undermine the government's ability to do that, you're then going to have more leaks about classified, important, confidential information, and that's going to, in the long run, degrade our effectiveness.
Of course, the two biggest leaks since the Pentagon Papers, the WikiLeaks trove and the Edward Snowden revelations, happened without a shield law. You would argue, though, that we will get more of that if there's a shield law?
It depends on how the shield law is crafted, and so I wouldn't say that you'll get more leaking necessarily if you have a shield law. It depends on how the shield law is designed, and I know Senator Schumer made the point that the one right now has what's called a national security exception. It's not really an exception, but it does address the government's need for national security, to maintain national security and be able to ferret out leaks that relate to national security. I don't think leaks are going to go away. I get that. But the reality is the government is very constrained already in the way that it goes after and investigates leaks. I mean, every day in newspapers and media across the country, there's classified information being published. That is actually against the Espionage Act. That is something that could be investigated and prosecuted, and the government doesn't do it. So the government has shown, the Department of Justice has shown restraint for all the right reasons in pursuing these cases, pursues those that are particularly egregious or go to particularly sensitive information, and have been selective about those as well. My concern is if you have a shield law that overly handicaps the government's ability to investigate those cases, then the leakers we really want to go after, who are, I would submit, people like Snowden and others, the government will be constrained in their ability to investigate those cases, and that'll encourage even more leaks.
Okay. Jonathan, you've spent much of your career dealing with the confidential sources and classified material, a lot of it in the area of national security. Has that job become appreciably harder, as I imagine it has, since 9/11? And would a shield law maybe improve your ability to do your job?
It's become much harder. And not dealing just with classified information. I understand why the government would go after leakers of secrets. But I've had conversations with sources about issues that or things that are not classified. And I remember talking to someone in a particular department of the government who said, "It's not classified. I can't talk to you about it because if they find out, they'll kill me." Now, that was a bit of hyperbole, but literally it's evidence of this, what we like to call a chilling effect by as a result of the crackdown on leaks. And let me talk about, because Laura talked about this, about sort of the susceptibility of people within the government and the protections that they don't have. I would submit that as hard as the government cracks down on leaks to prevent disclosures of the kind of things like Abu Ghraib, torture, this kind of thing, the more people inside the government, some people are going to be compelled and encouraged to leak, because these people don't take an oath to defend and protect the current administration. They take an oath to protect and defend the Constitution of the United States. And when they see, in their views, the Constitution being violated as a result of a government that goes way overboard in trying to attack terrorism, for instance, I think that there's going to be, that there are people who are going to be, who feel that it's their duty to leak. Now, as far as doing my job, it's become much harder. I think Peter Moss whipped out his iPhone and said, "I don't take this with me anymore." That's absolutely right. I try not to, I don't email sources. We just broke the story on the big fight between the CIA and the Senate Intelligence Committee. Most of the groundbreaking work on that was done by a 22-year-old paid freelancer who did nothing but doorstep committees on the Hill, go to people's homes, got me doing that again, going out at night to visit people. And that's how we were able to do that without sort of like sitting in the office and taking phone calls. One last thing, we do things like what Bob Woodward did. We give code names to our sources, so we don't talk about them, even in the office, using their real names. I don't know if any of you have watched the HBO series The Wire, but if you did, you know what a burner is. You go to CVS, you buy a cheap cell phone, you use it, you don't register it on your own computer, you use it for just a little while and then you throw it away. And I'm not going to go into other things that we do, except to say that I know where there are a lot of payphones still in Washington, D.C.
That work?
But and I think the fact is hotels, metro stations, this kind of thing. But I think that it's absolutely impossible, given the technology and the technological power that the government has now, to evade an electronic, to leave an electronic wake, to leave an electronic shadow behind you as you do this kind of thing. And yes, it's a hugely constraining problem.
Mm-hmm. The Shield Law does nothing to protect you from the technology.
In fact, no.
Does it do anything to reassure you in other ways?
I mean, I appreciate Senator Schumer's efforts and the people behind this, and I've got to point out that the President of the United States, when he was in the Senate, was a co-sponsor of a similar bill like this. But the fact is, when it comes to my reading of this, and I suggest that there's some profit to be made by Google Translator if they were to do a translation of Senate bills, because reading this thing is really quite cumbersome. But my impression is that yes, you'd go before a judge. But this bill says the judge has to give deference to the government's argument that you need to be compelled to testify because you've disclosed because you've violated some kind of national security regulation. So I'm disturbed by that. But the whole definition of threat, current threat or future threat to national security is so broad that we know that when, for instance, if you look at a government program called the Insider Threat Program, which this administration has instituted, which essentially says, makes it incumbent on government employees to basically inform on each other, and let their superiors know that this person is suspicious, they're drinking, or they've come into money that I didn't know they had, or this kind of thing. The fact is that this gives weight to the government's argument. Government goes to the judge and says, national security. The security offices in the CIA, Office of Security in the CIA, every single government department, including the Social Security Administration, the Peace Corps, the Department of Education now has an insider threat office that is tasked to determine who in the future might be an insider threat, might disclose government information. In the Department of Defense, their guidelines say leaks to journalists are akin to espionage, so that it treats us, journalists, patriotic journalists, as spies. So no, I don't get a lot of comfort out of this because of this broad definition of national security that these security offices will necessarily take and interpret in the most expansive way they can.
Okay. Quinn, you deal in a sort of netherworld. You report on hackers. You've had your own run-in with federal authorities in the Aaron Swartz case. Does this shield law have any relevance to your life at all, or is it a kind of legacy media issue that really is so 20th century?
I think one of the interesting things about this is that I, unlike almost everyone else who's been on the stage, never set out to be a national security reporter. I work on technology and culture, and I have for many years. And then national security came over and started squatting on my lawn. And so now I'm kind of transformed into partially a national security reporter because you guys all took over my internet in the early 2000s. But it isn't super relevant, and I'm not totally clear on how well it covers people who are doing freelance work on spec and things like that under what situations. But the thing is, like, anything can be national security at this point. Like I said, I never intended to be a national security reporter, and now I kind of am, because in the same way that everything is technology at this point, everything is national security at this point. All these categories that served us very well in the 20th century have gone very, very muddy. And you know, when you talk about the leaks can be damaging to government operations, sometimes that damage comes from public accountability. And that's exactly the kind of damage you want. And I would offer that, that the government is actually not the best arbiter of which operations should be damaged by public awareness. If public awareness is going to damage something that the government wants to do, in a democracy, that's supposed to happen. And we who are sitting outside of that system are maybe not in the best position, but we're in a better position. You know, who elected us? Well, you know, the majority of people doing these things aren't elected either. They're overseen by a very distant embodiment of elected power. But this is such a complex machine with so many moving parts that, you know, there's only 2 professions listed that I know of listed in the Constitution, us and pirates. And I think both.
Not in the same amendment.
No, not in the same one. No. But we're both very special. And I think we're also living at a point where, you know, who was a journalist in the 1700s and the 1800s was really, really well delineated by who had a big machine and the motivation to use it. And now what this needs to be about, the protection of speech in journalism as a method of accountability for a democracy, needs to be about acts of journalism, not being a stamped official journalist. Because people find themselves nowadays in the position of committing acts of journalism. And they get help from professional journalists sometimes, and they don't other times. And that needs to be a position that's supported so that people who are in that position make better choices. And when I look at not just WikiLeaks, but other places that have kind of taken on the burden of what was once more traditional journalism, I don't see a system that should be adversarial to traditional journalism. It should be cooperative. It should be helping. We all have the same common goal, which is informing a public, having a public that's better at making the decisions that a public is required to make in a democracy. And right now, this is all kind of out of whack. Because the things that we're talking about, what we have to do our jobs, I mean, the chilling effect is enormous. And right now, I mean, I think I'm in a really interesting position with the chilling effect myself, in that I've kind of taken a break from the active reporting because it's just so much work. I'm doing a lot more reflective and analytical work right now, and to be honest, that's because I just needed downtime. When you're reaching kind of the edge of human capacity, because of what you have to do in order to remain safe in your job, that is a significant chilling effect, and I'm going to guess that every other journalist on this panel and possibly in this room could actually speak to that somewhat. Like, the actual cognitive burden as well as the fear of all of these procedures we have to use. Does this protect me? Not really. I just don't think this, this doesn't go to the heart of the matter, this bill.
It's a very dispiriting lecture that you could give at the journalism schools, which seem to be packed with people who still think that there's some reason to go into this line of work. Scott, when we were talking before, you said your concern was that even, correct me if I've got this wrong, but that even if the intentions of the legislation were fine and the language is as good as it could get, you were concerned about the way an administration actually implements this kind of legislation.
That's right. I mean, I think we're coming here to an area where law and politics come very, very close together. And there's clearly an element of political decision-making along with the legal. And my thinking about this is formed a lot by discussions I had with Harold Tyler, who was my mentor, who was a Deputy Attorney General, ran the Justice Department under Levy. And he described to me at one point a long series of cases under the Ford administration in which the intelligence community came to the Justice Department asking to tap the phones of reporters, in one case to break into an apartment, in other cases to assign FBI agents to tail reporters, sometimes with the zealous support of certain figures in the White House, Donald Rumsfeld and Dick Cheney, no surprise. And Tyler and Levy consistently explained no, that this shouldn't be done, that it was a mistake. Their view was not that the law shouldn't give authority in exceptional circumstances to the justice system to take such steps, but that the Attorney General, weighing the situation as a whole, has to take into account our entire political culture and has to recognize that the best part of American tradition respects journalists and journalists' right to investigate and bring out facts that are painful to the government, even those respecting national security matters. And so I think there's an important element of political accountability shared, in fact, by the President and the Attorney General. And I think one problem with this legislation is a tendency to sort of mainstream the process, make it something that seems pretty routine that goes through and then goes to a judge and the judge is making the decision. Now, we can say that judicial check is a hallmark of democracy. It is. But the political accountability element is still an important one. And I think, and Tyler also raised with me a very serious concern he had about the way the Justice Department was being restructured. Because at that time, the division that Ken was the first leader of, the National Security Division, was being formed. He viewed that as a very serious structural error. Why? Because you had a division within the Department of Justice that was working effectively as a law firm for the intelligence community and would be their advocates within the Justice Department. So these requests, which previously had come from the intelligence community to the Attorney General or Deputy Attorney General, were now going to come with the imprimatur of an Assistant Attorney General and with the support of his staff. His big concern was that was going to change the dynamics of the process, and that was going to lead to more prosecutions and more subpoenas and more surveillance of journalists than was appropriate or healthy. And I think he was completely prescient. That is what has happened, and the structural element is a large part of the reason why.
Okay, Kurt, I realize you're not here as a surrogate for Senator Schumer, but you have been...
That's right, no pressure on me. Yeah,
right, you have been a very strong proponent of this legislation. I think are largely in favor of the version that Senator Schumer has arrived at. You've heard from Ken that this bill goes too far, and from everybody else that it goes not nearly far enough.
That to me is an indication that it probably strikes the right balance.
Oh, come on, that's a journalistic canard that just because it's hated from both sides, it must be right.
Well,
would you like to defend the bill against all comers?
Well, sure. I mean, if you don't like the bill, the question is, do you like the current situation where Jim Risen most likely, in a relatively short period of time, will have to decide whether he goes to prison to protect a source? In my view, the bill would actually, I'm sorry.
I'm sorry, just let me pause you on that one for a second. Do you agree with Senator Schumer that there's a reasonable chance that if this law were in effect, he would not face that choice?
Actually, yes.
Because the judge would weigh the balance and decide that the story that he wrote was of significant public value, and the damage to national security was commensurately less?
Well, I think there's actually a different reason, which is the national security exception, which is pretty narrow, in the context of a leak case. First, deals with properly classified information, and second, looks forward. So, the government gets to ask for your testimony only if it can prove that there is specific and articulable harm to the national security that it would either prevent or mitigate. Mm-hmm. So it's really looking forward at preventing a harm. And, Jim Risen is writing a book that was published in 2006 about a leak that occurred in 2003. Mm-hmm. It's about a country, Iran, that's very different now than it was then. It's very difficult for me to see how the government could prove that there's a national security harm that stems from that leak sufficient to require Jim to testify.
What about by trying to prevent future leaks? But that seems to be a major
deterrence.
Well, yeah, deterrence.
Well, there is a specific provision in the bill that says that can't be used to demonstrate harm to national security. So that, to me, is an indication that we've got a pretty good shot, if this bill were law and if we could get it applied to Jim's case, that it really would be efficient in keeping him out of jail. Okay. So in terms of the national security piece, another thing to remember is every confidential source is not in a national security case. There are at least as many and perhaps more journalists who've been threatened with jail in the past 10 years in civil litigation for money damages arising out of Privacy Act claims against the US government. So in the Wenho Lee case several years ago, there were 6 journalists held in contempt, including journalists from CBS, New York Times, Washington Post, AP. In the Stephen Hatfield case, Tony Losi was held in contempt and subject to $5,000 a day penalties that the court said she wasn't allowed to ask USA Today to pay for her. At that time, she was a professor, and she had an offer from her students to hold a bake sale so that she could help pay her contempt fines, which I thought was charming but ineffective. And she almost certainly would have been held in contempt and had to have gone to prison in a civil case for money damages had that case not settled. And David Ashenfelter, who is a reporter for the Detroit Free Press, is still litigating a Privacy Act case where he was held in contempt. In the Convertino case, there was a point when David had to decide, or may have had to decide, whether to go to prison in the same week that he was winning a Pulitzer Prize for his reporting. There's just something fundamentally wrong with that situation. This bill, in terms of these civil suits, wouldn't just take a step toward the problem, it would fix it. I mean, there would be no further confidential source cases coming out of civil litigation for money damages that would be effective after this bill passes. So there's a whole range of things it would actually do that would be highly productive for journalism as a whole, even outside the national security context.
Just to introduce a devil's advocate voice from the beyond, since you mentioned the Wenho Lee case, there have been some very distinguished members of the journalistic club who are skeptical of the Shield law. Anthony Lewis was one of them, yes. A great journalist, columnist, and a self-taught scholar of the Constitution. And he thought specifically of the case of Wenho Lee, a scientist who was accused of possibly having leaked secret technology. That this was a case where, as he would have put it, inadequate journalism tarnished this man's reputation, ruined his life. Why should the journalist be protected from helping him get some compensation for that?
Well, it's a fair normative point, but if you look at the balance of interests overall, and whether you can actually get sources in other types of investigations, my view has been that it's more important to protect the confidential source relationship in terms of future reporting than to say, well, we're going to force these reporters to testify because of the merits of a particular case. And the problem with that is once you force reporters to testify, or they can be jailed, that sends a broader signal to sources, and it really creates the kind of chilling effect that Jonathan was talking about.
Mm-hmm. Okay. Ken, do you want to respond to any of this? I sent you twitching a little bit.
Yeah, a couple things. Thanks. First, yeah, it is true that if you are a reporter, you're served with a subpoena, your testimony is demanded and you refuse in litigation, you could face contempt, and that could end up putting you in jail if you refuse. That would happen to me if I didn't want to testify about my neighbor, because I like my neighbor, but my neighbor is the subject of a criminal investigation. That would happen to any American who refuses to provide information in a criminal or civil proceeding. So the question is whether, because of the First Amendment, reporters should deserve special protection. But I think you got to remember, though, that everybody else doesn't have that protection. So it still goes back to the fundamental question about transparency versus security. Do we want to have a system whereby someone can leak, and really the person who's in the best position to tell the prosecutor who the leaker was is off limits? And, you know, I understand the rationale for it. I understand that there should be a check on it. My position is that there is a suitable check right now, and it's a self-imposed check. And I think we should be, I mean, I would be...
Sorry, what is that? What do you mean the self-imposed check?
It's self-imposed check if you look at the record of the Justice Department in terms of how often they subpoena reporters.
Oh, you mean the restraint, the inherent
restraint,
restraint
right.
of the Justice Department.
Look, if this is a situation where subpoenas are coming out every day, if there's a situation where reporters were prosecuted, if this is a situation where you know, contempt and jail terms were actually imposed on a regular basis, I would see a much stronger argument for a shield law. The reality is you don't see that right now. And if you know, we've all talked about the numbers, the several dozen subpoenas for source information that have been issued over the years, the fact that no reporter has ever been prosecuted in the history of this republic and never has to worry about being prosecuted. I mean, the Attorney General has said he wouldn't do that. I could never imagine it happening. And the fact that if you look at the cases that are pursued, that they're ones where there's something particularly egregious that has gone on. I think that is the best evidence that right now the calibration, you know, between transparency and security in the investigative prosecution realm is being struck pretty well. And I agree with the point that one result of this might be that this is now put on a judge. And if a judge says, boom, okay, fine, that subpoena is okay because it meets the needs of the statute. In some ways, that does undermine the political accountability. And don't forget, if you're a senior justice official, you're constantly thinking about what the political accountability is for you and for the administration. And you know that the person whose ox is gored is probably a member of the press, and members of the press have a way of getting their side of the story out. And so just look at the AP situation where there were the subpoena that was issued for whatever it was, 20-some lines for the AP reporter. You know, and there might be questions about, you know, whether that was overly broad, et cetera. But in terms of what they did, how they investigated the case fully before they did this as a last resort, got the records and ended up getting a conviction out of the case. I think a lot of people would say that's the way the system ought to work. Even that ended up with a huge firestorm, the administration on their heels, and you know, that I think is a good measure of the political accountability that does keep the Justice Department in check. So I wonder whether if you start putting this in the lap of a judge, you get a judge's imprimatur on the executive branch's decision, that in some ways might even undermine that political accountability that I think the track record shows has held the Justice Department in check for over 2 centuries.
But you're talking about formal cases, prosecutions where subpoenas are issued, and we know that at least until 2006, the FBI was going in and collecting information, telephone information on journalists. I think the New York Times got collected on, the Washington Post got collected on. It only came out because the Justice Department's Inspector General went and took an examination to examine that. There was and as a result of that, disclosed an OLC, this is the Office of Legal Counsel decision, which basically said the FBI actually has the power to collect this kind of information without a formal court ruling, without any kind of subpoena. They just haven't used it yet. Now we're assured, at least since 2006, I believe it was when we learned about this. Actually, we learned about it a little later, that they've never used that particular power. But I don't think there's ever been a case where they've said, actually, you know, we're never going to use. I don't think there's any kind of formal restraint that's been enunciated that says they're never going to use it and it's illegal. Actually, the opinion, I'll say, correct me if I'm wrong, actually says they can do this, they just haven't yet.
Kurt?
On the point of numbers, and this is always a difficult one because I think in our view, the Justice Department always underreports the number of subpoenas. They didn't report, for example, the subpoena that put Judy Miller in jail and almost put Matt Cooper in jail because they said it was done by an independent prosecutor and not the Department of Justice. They also tend not to report the AUSA subpoenas in the field. There was a study that, instead of looking at self-reporting, went the other way and asked journalism outlets, how many did you receive in the same year? That the Department of Justice said it was 19, and it came out to be 67. So, there's the numbers game is really not the place.
Yeah, and I've been down this road before, but keep in mind that I was, assistant U.S. attorney and U.S. attorney for 15 years, and I sent a lot of subpoenas to media outlets. They knew it was coming. They agreed that they would receive it and they would satisfy it.
Of course.
But that was for outtakes from a newscast. That was for information that wasn't source-related information. The reason why, and so that might be the 67 that news.
41 of them are seeking a confidential source. So 41 of the 67.
See, here's the and 41 over the course of history.
In a year.
Yes.
Okay. Well, see, this is the thing that's surprising to me about that, because the Attorney General of the United States has to personally certify and approve that, and that's why I'm very skeptical that there are 41 of those kind of subpoenas that are issued, and that the Justice Department is somehow not capturing those. You usually capture things that go across the AG's desk.
Right, absolutely. And just as an aside, I know the Justice Department takes this seriously. And we're a big fan of the internal rules that the Justice Department has. And in fact, in terms of the political accountability point, the current draft of the SHIELD bill actually builds them in and says the Attorney General has to certify that those rules have been complied with, really for that political accountability point, to try to maintain the discipline that has grown up over the years within the department on that point.
And that discipline that is enhanced with the new guidelines that just recently came out, maybe doesn't go far enough for you, but does address a couple of the main things that have got people riled up over the last year. The use of the carve-out with the Rosen situation, making him a conspirator, and then also the notice issue that was really front and center after the AP situation. It expressly addresses both of those concerns.
Yeah, the notice situation is much improved under the new rules. It updates, where it used to apply just to telephone records, it sort of goes broader because we're not just dealing with telephone issues anymore. But I do find the Director of National Intelligence trump card to be troubling, and the fact that they've now sort of gone to a definition of ordinary news gathering for the applicability of the guidelines rather than just news gathering is concerning to me. And I hope there will be further improvements. But what is ordinary news gathering in an era where some people call journalists accomplices to their sources? That's a concern.
Yeah, and that kind of gets to a little bit about, for me, the biggest problem with something like a SHIELD law is that we're getting to the point where you don't really need a subpoena. I am in a class of people who are fairly well surveilled, and it is hard for me to know whether or not I've already given up my sources. And are the measures that one takes to guard against that? I heard from an earlier panelist that maybe using encryption does flag you as possibly involved in criminality. Are the measures that one takes, does that take you out of ordinary news gathering? If you are trying to protect your sources, are you more of a target? And I don't think anyone can adequately answer that. And I would love to see, I don't expect to ever see, but I would love to see some legislation that recognizes that the techniques of surveillance are chilling to journalism and addresses that.
You were saying before when we were talking that we're now in a realm where in order to protect your sources, you often don't know who they are.
Yeah, I take fairly extraordinary
Which I think is probably not the case in Jonathan's reporting.
Yeah, given the people that I'm dealing with, and
who are people like Anonymous and hackers and...
Yeah, I reported extensively on Anonymous, and these are people who are straight up criminal. Well, let me make something very clear. Most of Anonymous aren't criminals and never break any laws. They are engaged in speech acts and messing around. Speech acts and pranks, which are also speech acts. But when I worked with a specific group, which was at the time infiltrated by the FBI, they were specifically trying to commit crimes. And so in order to work with them in a way that was safe, knowing this up front, believing this was newsworthy, which I believe our coverage supported over time. And these were very much politically motivated crimes, but we were all really clear that they were crimes. I had to design coverage in which I could verify the facts using outside experts, looking through data, and using timing and other techniques and building relationships with people without ever knowing who they are. And in fact, with many of my sources, if we would have the kind of intimate conversations you have when you're building trust with a source, but if they started giving me too much identifying information, I would stop them. I had a rule that if I knew who you were, I wouldn't talk to you anymore. And a lot of that was about not being able to respond to a subpoena. And also, and I really, really want to make this point for journalists who want to use encryption, starting to use encryption when you're talking about something interesting is a terrible idea. I use encryption when I chat with my 11-year-old daughter. I can stand up in front of a federal judge and say, encryption is my norm. There is nothing extraordinary about any conversation that was encrypted. All of this was designed and vetted by lawyers to keep me safe and to keep my sources safe. But as I have no particular interest in going to jail to protect my sources, I saw it as also to keep me safe.
Excellent. In the wider world outside of this auditorium and outside of the world of people who practice journalism, I think people often have a hard time making a clear distinction, let's say a moral distinction, between leakers and journalists. A lot of people, I know from WikiLeaks experience, revere Julian Assange, but they also revere Bradley Manning and think that he is a hero. And there certainly are a lot of people who not only admire what the journalists who were here earlier do, but think that Edward Snowden is a hero. And I guess the question is, and to those people, a group of journalists sitting around talking about how the law should protect journalists, but not those other guys, sounds self-serving. Do we have, as journalists, some obligation to advocate stronger laws, stronger protections for leakers / whistleblowers?
First off, her name is Chelsea Manning.
Right, but it wasn't at the time, though.
Yes, but at this point it is. And secondly, I think that the first incumbent duty on us is to make sure that our sources are entering into a relationship of informed consent. As I often say with many of the encryption tools, things like Tor, which I'm sure people here have used, I often say it's more important that my sources know how to use it than I do. To some degree, I need to know how to use it so I can teach sources at times. But in the daily gathering of news or working a story, I don't have a chance to push for particular legislation. But I do think, like, if I explain that informed consent, if I explain the status of my sources, I give the public the opportunity to weigh in on that question in a useful way. With my sources, in some cases, yeah, I do think that there's probably forms of leaking that should be better protected. In some cases, the people I'm dealing with, it is clear that they have set out to commit a crime. I don't really feel like I am welcome to weigh in, to some degree, to say whether or not, they've made a determination. But that's a spectrum, And then there's other people who, I have friends who faced Computer Fraud and Abuse Act charges based on what was, from a technical point of view, fairly routine information gathering. And that's a place, kind of separate from a lot of what we're talking about right now, where the law is really out of control. But yes, when fairly routine technical things can be called CFA felonies, I have advocated publicly for reform of that law because it's just not coherent at this point. It's an old law and it doesn't make sense on the internet. When I'm working with somebody who's specifically an anarchist setting out to make a point about the government, I build that into my coverage. I don't want to just give them a blank platform for that, although I do think that that is a view that should be in the mix, that there are many views that are represented in this, and it's part of news as well. But more than anything, I think when I am turning to that source, I need to make sure they understand where their legal protections are and aren't. And I think it's really important for journalists to learn enough to be able to educate their sources so that their sources can make that decision and not get surprised by what happens next.
Good point. Scott?
I think, yeah, I think there's a huge problem right now. I think recent developments, the Drake case, the Snowden case, also a number of others, really show that the whistleblower process doesn't work. It's broken completely. And I think from a journalistic perspective, there's valuable information that's being provided about ineptitude, stupidity, criminality, corruption, that the public needs to know, that Congress needs to know. It's just as good for that to come out through hearings on Capitol Hill with witnesses and evidence being produced as through publications in the newspapers. Newspaper publications and leaks in that form, frankly, should be a fallback in our democratic system. But the fact of the matter is that the whistleblower system has been short-circuited. It doesn't work anymore. I mean, whistleblowers with information who in the past would have gone to the Senate Select Committee or the House Select Committee now feel they're going to be observed the instant they go there and attempt to communicate. They'll be viewed as traitors. They'll be spied upon. And I think now we have a certain senator from California acknowledging that, yes, they are spied upon. So I think we have really something that rises to the level of a constitutional crisis here that does seriously impact the way we work and gives unfair advantage to those in the intelligence community who want to stem the flow of vital information.
Ken, you want to?
If I just add to that, actually, I agree with your point about the whistleblower protections in the following way. Look, you know, there are a range of different motives that lead people to leak. Obviously, if they're a spy, a Robert Hansen type, no sympathy for that. A lot of people leak, at least in part, because it makes them feel important. They're in the know. They show they're in the know. It makes them feel good to do it. I don't have much sympathy for that. I do have sympathy for the actual whistleblower, and I understand that. There are instances, we've seen them, where people have, for the right reasons, because they're concerned about their government and things they see in the government, have gone to the press and laid out what they disagree with. I don't know that we can have a system that allows every person to unilaterally decide what should remain secret and what shouldn't remain secret, but if you sort of put aside that systemic issue, I do understand where whistleblowers are coming from, and it's incumbent on the government to have a process that allows a whistleblower within an agency to raise his or her concerns, get them heard, be protected from retaliation, and be confident that if there is a need for change, that there will be change made by maybe the congressional committees, the intelligence committees. That system, you say it's broken now, I'm just not sure it ever actually became as effective as it needs to be. And that is, I think, if the government's ever going to remedy as best it can the leaking situation, it's incumbent on the government to make sure that there's a system in place where people feel there's a user-friendly whistleblower system that I can get my issues raised, because if that happens, and there really is that avenue to get redress or get correction of what somebody sees as wrong, then there really isn't a justification for a government employee to go outside and go to the press, because then they're just doing that because they disagree with policy. And frankly, I don't think that that's a reason why someone should be allowed to violate their oath.
We completely agree on this.
On that harmonious note, we're out of time. So let's thank our panelists for their thoughts.